This is case number 211-69362. This is April Durham versus Best Deals Auto Sales. The matter is set before the court for a pretrial conference on today's date. Do I have April Durham on the Zoom? Say something if you're here. Ms. Durham. For Best Sales, please, your appearance.
Good morning, Your Honor. Brent Cradiville, 75845, appearing for Best Deals Auto Sales.
All right, thank you, counsel. Good morning to you.
Good morning.
So go ahead and update me. I know this has been up in front of me a couple of times, and I know that Ms. Durham was here on a previous occasion. So go ahead.
Yes, Your Honor. So this is a suit originally filed by Ms. Duran in small claims court, removed to general civil, and then a counter complaint was filed by my office. Ms. Duran filed an answer. After the last pretrial where you ordered her to file an answer within a certain amount of days, she did do that. And I actually have not spoken to her since the last pretrial. So I'm not sure why she wouldn't be here today. That's essentially the extent of it. We're suing for breach of contract. Her suit's a little more amorphous than that.
All right, got it. All right, that is a correct recital of what the status of this matter is at this time. I do have the answer to the counterclaim as well. And Ms. Durham has been here on previous occasions. Again, I'm looking for April Durham on Orleans Street. All right, so under the circumstances, I suppose that you are moving to dismiss the complaint in this matter and perhaps applying for judgment on the counterclaim. The court will take such motions under advisement, and I'm going to set a new date. If the defendant does not appear at that time, the court will certainly dismiss the complaint and then be heard regarding an issue at that time. So I'm going to set a date about 30 days since trying to get Durham in here.
Okay. And would you like me to wait until that date to file the? Okay, that's fine. We can do this again in 30 days, and then if she's not there, we can go from there.
Yeah, I'm going to give you the date, and of course, I'm indicating.
Hi. Hello.
Hello, who's that?
April Duran.
Oh, man, I've been calling for you. Good morning to you.
Good morning. I'm sorry, I had my headphones in. I've been sitting in court. I think you got in at 10 o'clock. I'm sorry.
All right, not a problem. Not a problem. All right, so we kind of did an update or status as to where things are now. You filed a complaint, and of course, plaintiff strike that defendant has answered that, and then they filed a counterclaim against you. And I do see where you answered on the you filed a response to the counterclaim in this matter. All right, so is there some discovery that's needed in this matter? Exchange of information between the parties before proceeding further, counsel?
I don't need any discovery, Your Honor. We discussed last hearing the possibility of filing a motion. A motion was not filed on my behalf. I still think that's a possibility. I don't know if the court wants to grant any more time to do so.
Ms. Durham, the stage of the case now with the parties having presented their information to court, their pleadings, I should indicate, is and now that the parties have an opportunity to request discovery if they believe that the other side has any information under their control that might be helpful to a particular party. Secondly, it's an opportunity for the parties to file motions asking that the court make a decision on a case based upon the filing of a motion. A motion is a document requesting that the court do something, such as a motion to dismiss, a motion for judgment on the pleadings, items along those lines. So
Yes.
Those are the two things that I'm looking at right now is the possibility of either side filing a motion, as well as any need or request that either side may have with respect to any documents or any items of evidence that may be under the other party's control. All right, you understand what I'm talking about, ma'am?
Yes, sir. I filed a motion. You told me to have it in by, I filed the motion already.
Well, I didn't see a motion filed by you. I see where
Yes,
you
I have.
filed your answer. I see where you filed your answer to the complaint.
And,
What-
and I also filed a motion. I have both of them right here.
Yeah, well, you have them right there. I don't have them right here. So let me
I'm sorry.
ask you, what motion did you file?
I filed a motion. She told me to file both of them. Here it is right here. Hold on, let me see. I got two of them. I got a one and then,
So tell me what it is. Tell me what you titled your motion.
well, I
Go
think
ahead.
it say answer civil. So I thought I had another one to file the motion because I was supposed to have it in by the 7th. That's what you told me to have it in.
All right, I'm looking through here now. Let me see what I've got. I do have your answer. That's the most prominent thing that I see. I also see a motion. It says, please grant my request. It said, Best Deal Auto not honor my warranty. My transmission busted the first day I left the lot. They say they were putting a transmission and it car never drove right. I told my police to file a small claims. I was told by police to file a small claims, and that's what I did. They should pay me my money back, all the problems, etc. All right, so yeah, I see what you're talking about. That is in the nature of a response to the complaint. You have filed it as a motion. Counsel, did you get a copy of the motion?
No, Your Honor. I mean, I have the answer, the 2-page answer that was filed on the 13th of June. I'm looking right now through my hard file to see if there's other paperwork. I don't see it, Your Honor.
All right, very well. So, so what I'm going to do is, ma'am, I'm going to have my clerk to email counsel a copy of the motion that you filed. We're going to set that for hearing, and I'm also going to set a date. The date that I'm going to set for hearing is going to allow for any motion that the other party may file as well to be heard on the same date. What Ms. Durham did is she attached to that document, and it was behind the answer that was filed with the court. She attached to that document a vehicle protection plan, service agreement as a part of her motion. So, counsel, we're going to make sure that a copy of that attachment, as well as the handwritten motion, is sent out to your office. And what I'm going to do is I'm going to set a motion hearing date. That date is going to be.
You said 30 days.
Yeah, a little more than 30 days.
The 31st of July. I mean, 31st of August.
I'm going to go ahead and set that date for August 31st, 8/31, 22. I'm going to set it at 9:45 a.m. The parties respectively have the right to file responses to the various motions if you wish to do so. You must file any response within 10 days of the hearing date. Moreover, if Best Deals decide to file any motion, all you need to do is make sure that you give Ms. Durham at least 10 days prior to the hearing to respond to the motion. The reason I'm going over that for both parties is because the timeline on these motions that might be motions for summary disposition is being made shorter than what the court rules would normally allow. But by order of this court, I'm shortening the time period so that Ms. Durham has already filed her motion. Counsel has at least 10 days prior to the hearing to file a response to that motion. And then if counsel for Best Deals files a motion, Ms. Durham, you will have at least 10 days before the hearing to file something in response to that if you wish to do so. The hearing will take place on the 31st of August at 9:45 a.m. And Mr. I'm having a problem with your last name, Mr. K.
It's credible.
If you will chat us, and let me see if I've already got it. Just one moment here.
I actually changed my name, Your Honor, on the screen. I don't know if that helps, but I can also chat my email. Is that what you're going to ask for?
Yeah, that's what I was asking for. If you will chat the email address, your email address, I'll get my clerk to send a copy of Ms. Durham's motion and the attachment to you, right? Right, so I wish both sides well, and I do see your information, counsel, and I'll make sure that that the item gets sent to that particular email address today. Right. All right. Thank you, Ms. Durham.
Thank you.
We'll be sending a notice out for August 31st, but you want to note it anyway, August 31st, 9:45 a.m.
Okay, thank you.
Thank you, Your Honor.
All right, good day to you. One moment. All right, this is case number 21-164-937. This is Andrea Wilson versus Nationwide Mutual Insurance. The matter is before the court set on for a review on the days date. I know that the parties recently had a facilitation regarding this matter. For the plaintiff, please.
Joseph Falls on behalf of the plaintiff, Your Honor. P80521.
I'm sorry, sir. I interrupted you. Go ahead again.
I'm sorry, sir. P80521.
All right. Thank you, Mr. Falzon. For the defendant, Nationwide, you may at this time, please.
Good morning, Your Honor. Anthony Sinisha on behalf of defendant, P number 82128.
All right. Thank you, counsel. And good morning to you as well. Somebody update me regarding this matter, if you will.
Yes, Your Honor. This is a case filed by claimant Andrea Wilson in regards to a motor vehicle accident. Some of her medical providers have also filed separate provider suits in different courts. One of those cases was just, we just had case evaluation, and it will be essentially put into facilitation as well. And in another one of the cases, we have a motion to compel one of the treating medical providers' depositions. At this point, unfortunately, we haven't done the facilitation on this case. Our hope is to essentially bind these together and do one facilitation after the deposition of that one provider, and try to get as many of the cases settled in one go as possible.
Your Honor, I just want to say for the record that I just substituted on this case. Prior counsel was Ms. Cooley, who's just no longer with the firm. And I did just, in review of the case, I did see that little note. I believe that my legal assistant was sending out an email today, because I just found it today, as to what's going on with the facilitation. We have no issue with facilitating. I spoke with my client this morning. She's on board with it. So as soon as brother counsel can tell, get that going with the other cases being involved, I'm more than happy to participate, get this case resolved.
That makes sense. And the global nature of the attempt to find some resolution is quite meaningful here. So how much time, what kind of tail you think you need on this? Do I need to take another look at this in 30 days or?
If we could get 60 days, Your Honor, I think that would give us more time to allow for the motion to compel to go, and then see if that provider actually shows up or not. And then we'll get a better idea of whether or not that party should be involved in facilitation. If it seems like they're not cooperating, we'll probably file a motion for summary disposition in that case, and then just worry about the other providers and putting them together with this facilitation.
Is that motion already pending with regard to compelling the testimony of that particular person?
Yes, Your Honor, that motion has already been filed. Let me see if we have a hearing date. Our hearing date is August 12th on that motion.
All right, Mr. Falzon, on the time frame.
I have no problem with the 60 days. All I was wondering is with your motion to compel, are you just seeking that the dep occur within 2 weeks, or I'm trying to figure out a timeline here?
Yep, let me pull that up.
I suppose that you guys can work on those logistics, and if you need a breakout room, I'll do that. 60 days is like way out there, it seems to me, but it does not seem unreasonable under the circumstances here. It seems that the parties are making some progress towards getting to the bottom line on this. So I'll go ahead and set it over for review in 60 days, and that specific date is going to be
31st, that 31st, no, because the other week you're off. Audit, yeah.
That's sooner than 60 days. Can you put it a little bit?
Oh, you want past that?
Yeah, just a little bit.
Okay,
Middle,
September, so you're talking about like that September the 13th, 14th?
Yeah, September 13, 9/13, 2022, and I'll go ahead and set that review at 9:30 on that date.
I'm sorry, what was that date? It froze up on me.
9/13/22, 9:30 a.m.
Thank you, Your Honor.
All right, thank you, gentlemen. And
Thank you, Your
all
Honor.
this matter. All right, good day to you.
You as well. Thank you.
The board now calls case number 21-240898. This is Michelle Maxwell versus Dion Doyon, Detroit Realtor. The matter is before the court set on regarding the issuance of a subpoena. Do I have Michelle Maxwell regarding this matter?
Yes.
All right, good morning to you, Ms. Maxwell. Do I have someone from Doyle Detroit Realtor on the Zoom? If you're on the Zoom, please say something. Just one moment, ma'am. Again, the court is calling from anyone for on the suffix 0898 Doyne Detroit Realtor, reportedly located in Livonia. If you're on the Zoom, please say something. All right, the record should reflect in this matter that a judgment was entered in this case on the 9th of March 2022. That judgment was entered by default for the total amount of $3,000. A subpoena did issue regarding this matter. That subpoena was issued by this court on 6/15/22. The subpoena set a hearing date of today's date at 9:45 a.m. The subpoena made demand for proof of compliance of safety inspection, something about original deed, etc. Now, ma'am, was this document served on the other side?
Yes.
Did you file a proof of service with the court?
Yes, they said they were gonna send it out for me when I did it at the court.
I don't have anything showing that. So who did you have serve the subpoena, please?
When I filed the motion, I filed for it to be sent out, and they told me that they would send it out for me. I didn't have to do anything else.
All right. So did you get anything from any process server, anybody telling you that it had been served?
No, I didn't.
Okay. Let me ask you, what are you trying to achieve? Tell me what you're trying to do. You got a judgment. What are you trying to do?
Just collect it.
All right.
And
So
this is the process they told me to fill out.
Okay. So why you? Yeah, I see the subpoena, but you're subpoenaed for proof of compliance, original deed of all ownership, current lease, or what are you getting at there? I guess is what I'm. So I'm kind of trying to find out where you are with this. I see that
I'm
you.
just, they never responded, they never answered. I'm just trying to collect. That's it.
You know,
Because
I
the
know all
default,
that. You got
I'm
the
sorry.
default judgment. Also, sorry, I said, I know that you got the judgment, that they didn't respond. I got all of that. I already went over that. I also signed a requested order for seizure of property. Did you turn that over? Did you hire a bailiff or a court officer to go and seize property for you?
When I filled it out down there at the 36th district, they told me that they were going to send all that out. I filled that waiver out for them to send it out for me. And so they told me it was nothing else I had to do but just show up. And then I have to show up for today. They sent that to me.
Let me check something on this. Let's do a.
Mhm.
I'll look at the register of action to see if I got any notation regarding service of those documents. Obviously, you already completed the information regarding the judgment, but any subsequent documents, subpoenas and what have you, they have to be served, and a proof of service has to be established in that regard. And then you also you filed a request to excuse me, you filed a request to seize, and if you've got somebody identified, oftentimes you pick a court officer or someone, hire some agency to enforce that for you. But let me just look at see what's going on. Just one. Right, so the record should reflect that on review of the register of actions, it seems that items were sent out from the court regarding this particular court date. All right, ma'am. So what I do have is information that the court sent out a court date notice in this regard. So what I'm going to do is, given that the defendant has not appeared for this particular court date, I'm going to issue an order to show cause. And the show cause order will order that the defendant show up, or a bench warrant would be issued in that regard. Now, who is Deneen, or I understand it's a real estate company or something. You didn't sue an individual or anything, correct?
Correct.
Do you know who the agent or any person involved with that realtor company is? Do you know who that person is?
I don't know right off of hand.
Okay.
I can't think of it.
All right. So your I guess your your best approach at doing this is to see if you can make contact with a court officer, either at this court or at some other court, and advise them that you want to hire them to execute on a seizure of property, so that they could, with me signing that order, I signed it back on the 15th of June. With that signed order, that gives a court officer or deputy sheriff the right to go to the location, the premises, and to collect on your judgment by seizing property or whatever it is that may exist at the premises there in Livonia.
Okay. So where,
yeah.
I'm sorry, so I come back down there and get a court officer, or
What I'm saying is that your shortest distance between 2 points is probably to hire a court officer or someone that is licensed in the state of Michigan to enforce the judgment, and then have them to go to the premises to seize property. Because I already signed an order allowing for seizure. And you could do that. You could make contact with the bailiff's office here and tell them that Judge Coleman has signed at my request to seize property, and I'd like to have somebody to execute that seizure of property. And, and then you would go from there. What I want you to do also is I want you to put in the chat an email address where I can email you a copy of the signed order for seizure. So if you put your email address in, I'll make sure that a copy of that gets sent to you, because I signed that back in June.
Okay.
Okay, so chat your address and we'll do that. I'm also going to set a show calls date. We'll send another notice out to the company with a show calls date. And that date is going to be we'll go ahead and set it 31st of August.
Okay.
31st of August. That's going to be at 9:30, 8:31 at 9:30. And you'll get a notice with that date on it as well.
Okay.
And they'll get a notice. It's called a show cause hearing. There's a document that's going to be sent out to them as well. But that's the date that you'll come back for the hearing. In between, make sure you chat me your information so that I can send out a copy of this signed order to seize property, and then contact the bailiff's office and request the bailiff to execute on your seizure order. Understand? Okay,
so that's what I'll do in between time.
Yeah, and if that works out, you don't even have to worry about the other part.
Okay. All right.
If you get if they seize property and get your money, then you don't even have to worry about the hearing. You already got taken care of what you need to take care of. But if that doesn't work, then show up for the hearing and let's deal with the show cause then.
Okay, thank you. Now you want me to, you know how to chat it.
Yeah. So use your electronic device and put in the chat before you hang up. Put in the chat your information, and I'll make sure that a copy of that order gets out to you. All right.
Okay, I'm putting it in there now.
All right. All right. Thank you, ma'am. See you soon.
Okay, thank you. Let me put it in there now.
All right. This is case number 22-181561. This is Lear Corporation versus Lane Costigian, I believe it's pronounced. The matter is before the court, set on for a hearing. I believe that this is the initial hearing. As the court has received the joining of the matter, the defendant has filed its answer in this regard. Your appearance for plaintiff, please.
Good afternoon, Your Honor. Michelle Kochmeyer on behalf of Lear Corporation.
All right. Good morning to you, Madam Counsel, and your P number, if you will, for the record, please.
P81355.
All right. Thank you. Counsel, your appearance for the defendant in this matter, please.
Good morning, Your Honor. Lawrence Gadd on behalf of Lane Costigian, P46282.
Thank you, Mr. Gadd, and good morning to you as well. All right, so it looks like, as I indicated, this is the initial hearing, the matter just became joint. My inclination is to go ahead and open a period of discovery. Have you guys talked about this?
Yes, Your Honor. We've been talking. We're pretty close. I'm pretty confident we can get this involved in the next 30 days, if not sooner, hopefully.
Madam Counsel?
Yes, Your Honor, we have had several conversations seeking a potential resolution. I'm confident that we can reach an agreement, but I would like to set some time for discovery in the meantime, to the extent that it's needed.
Yeah, I guess my thought is that if you are working towards resolving it, that will not compromise me setting a discovery order. That means that we would know in the short term if you're going to be able to get it resolved. So if you think that maybe I set it over for 21 days or so and come back and review it, and if you've been able to resolve it, of course, that will in the case be resolved. But if you haven't, then at that point, I would set up a schedule for discovery in case we begin to move forward.
That sounds fine, Your Honor.
That
Fair enough.
would not prejudice anything. It just is feeding into what the two of you have said, that you might, with maybe a few more weeks, you might be able to find a way to a conclusion. So I'd like to give that a try.
Yeah, I mean, I'm happy to do that, Your Honor. My only, I guess, concern with that approach would be that, you know, we're going to know pretty quickly here whether we can resolve this or not. You know, it's 17 grand. She can either pay it or not. And if she can't, I mean, look, we're going to have to do some discovery. So I'm happy. I think the desire on both ends is for resolution. But, you know, to the extent that it doesn't get resolved, which again, I think we'll know here in the next, you know, few days, then we're going to need to do some discovery. So happy to do it either way, but just with some context there.
Sounds good. I appreciate the context. I will go ahead and set it over for about 3 weeks, so we can get it back as quick as we can. And I'll set that for a review. And on that review date, obviously, if you've been able to get it resolved, we'll know that. If not, I will set up the schedule for discovery and motions at that time, and you'll be on.
Sounds like a good plan, Your Honor.
August 4th.
August 4th is the next action date. August 4th, that's going to be at 9:45 a.m. August 4th.
Okay. Yep, I think
right.
that works.
And I'll see you at that time, and we'll know what the status of things are.
Fair enough. Thank you, Your Honor.
Thank you, Your Honor.
All right, this was Regents versus David Allen.
Yeah, that one is, that's just a regular case. It's a show cause today. Unless we don't have we have 5. That's an old case.
Yeah, should I call it?
Yes.
Oh,
It's on here.
this is case number 15-123-726. This is Regents of the University of Michigan versus David Allen. That is before the court on a petition in order to show cause. Your appearance in this regard for plaintiff?
For the record, Your Honor, Stuart Collis, P49530 on behalf of the plaintiff.
Thank you, Mr. Collis. Good morning to you, sir. Do I have David Allen or somebody representing Mr. Allen regarding this matter? All right, so what's going on here, counsel? I know that this is a 2015 case. Looks like there was a judgment, and so go ahead and tell me about this a little bit.
Yes, Your Honor. We had a scheduled creditor's exam back on June 13. Mr. Allen didn't show up at that time. You said that you would set a show cause for today's date. He's again not here today.
All right. And that's what my records reflect regarding this matter as well, sir. Accordingly, the court will now, on your application, issue a bench warrant regarding this matter. And the court will set bond on the bench warrant I see the judgment upon entry was 2634.92. Do you have some calculation as to what the balance might be at this time, sir?
Balance as of today's date appears to be $2,318.82.
All right, so the court will set bond on the bench warrant at $2,500 cash. And I'll sign an order consistent therewith. You'll fill out the application. You can either send it in or email it in, and we'll get it signed up so you're ready to go in that regard.
All right, thank you so much, Your Honor.
Thank you, Counsel. Good day to you. This is case number 211501, strike that 25, strike that 21151072. This is Affiliated Diagnostics of Oakland LLC versus City of Detroit. And your appearance regarding this matter, please.
Good morning, Your Honor. Ian Coot, 73154 for the plaintiff.
All right, thank you. Good morning to you, sir. For the City of Detroit, please.
Good morning, Your Honor. Yvonne Bradley for the City of Detroit, P54885.
Thank you, Ms. Bradley, and good morning to you as well. I see in front of me, there's a defendant, City of Detroit reply to plaintiff's second motion to reinstate case. So it looks like this matter was dismissed sometime in June of 2020. So what's going on? Somebody tell me about your motion, counsel.
Yeah, thank you, Your Honor. The case was filed back in March of 2021. In May, the court issued a notice to appear for a pretrial on June 9th. Our office received that notice on June 22nd. I drafted a motion shortly thereafter at the end of June to reinstate, and then asked for it to be filed. I think our office missed something in that process, and we filed it in April of this year. So essentially, we're saying there's good cause to set it aside. We didn't get notice of the pretrial timely. And, you know, kind of looking at the prejudice to both parties, if the plaintiff's case were refiled, we would not be able to collect any of the dates of service because it's gone too long and they're more than a year after they were incurred. I think the prejudice to the defendant is less than that. It's all I saw argued was the passage of time and getting the motion filed. And admittedly, there was a bit of time between when we drafted the motion and when we got it filed. But I think on the whole, the equity way in favor of setting aside the dismissal and allowing the parties to proceed to toward trial anyway.
Thank you, counsel. Ms. Bradley, you may at this time, ma'am.
Yes, Judge, there are three issues with respect to plaintiff's motion: the failure to appear, tolling, of course, and that's in conjunction with the 1-year back rule. Your Honor, as you're aware, the plaintiff filed this complaint in March 9th of 2021. The court scheduled a pretrial conference and plaintiff failed to appear. According to the attachment to plaintiff's motion, they indicated that they received the order of dismissal from this court on June 14, 2021. That's the day stamp from plaintiff's counsel's office on the attachment. Plaintiff did not file a motion to reinstate the case, their first motion to reinstate this case, until March 24, 2022. That's 10 months after this court dismissed the first action. And for the hearing of May 31, 2022, plaintiff did not appear. As I understand it, Your Honor took copious notes and actually made notice of that failure to appear, not just for the pretrial conference, even if plaintiff did not get notice in time. They received the order of dismissal and still filed their motion to reinstate 10 months later, and then didn't appear for that. So with respect to that timing, we think that there's an inexcusable delay. With respect to tolling and the one-year back rule, Judge, plaintiff again filed this action on March 9th, 2021 for dates of service of June 3rd, 2020. That meant they filed that action 9 months and 6 days after the date of service, which meant that they had 2 months and 6 days to file the action. They filed the action on March 9th. This matter was then dismissed on May 31st. I'm sorry, on June 9th of 2021, and it has still been dismissed. Tolling would have only allowed them to continue this action through, just say, early September. But we are now, Judge, a whole year, as of today, a whole year, actually, more than a year, after the court dismissed this action initially. So not just with respect to tolling only gave them 2 months and 6 days, but they are well beyond that. And then the one-year back rule only allows them a year from the latest date of service, which would have been June 3rd, 2021. We are now in July of 2022. Defendants oppose this motion. We think that it is there is undue delay and it is barred, and tolling does not benefit the plaintiff. So we would ask the court to deny the motion.
All right, well, on the issue with regard to plaintiffs indicating to the court the effect, the prejudicial effect that would occur if the court does not reinstate the case with retroactive application. The effect of that is, of course, the denial of a potentially valid claim. Anything you wanted to say in addressing that aspect of this? In terms of the weighing of the various prejudice, what harm does it do to the defendant versus the apparent harm that it would potentially cause to the plaintiff in this matter? Counsel, you want to address any of that?
You're speaking to me, Your Honor?
Yes, Ms. Bradley, I'm sorry.
That's okay. Sure. Okay. So first of all, the No Fault Act specifically identifies a period of time for which a party or a claimant can bring a claim. The No Fault Act specifically states that if you miss that time, that 1 year timeline, then your claim is barred. In this particular instance, we have plaintiff who just disregarded or for whatever reason is now pursuing this still a year later. There is an inability on the part of this defendant to obtain information potentially that may have been relevant or pertinent at that particular time when this claim was filed or when those dates of service had occurred, the IMEs, various things that the defendants could have done to defend this case, which are now more than a year outside of that. So we're talking about more than 2 years outside of the date of service that this plaintiff is now trying to claim for, and defendants don't have the benefit of seeing what the condition was at that time. The defendant is prejudiced by not being able to properly defend the action or the claim pursuant to the No Fault Act, which specifically states if you miss the time, you lose the claim.
All right. Thank you, Madam Counsel. You get the last word, Mr. Cool.
Yeah, Your Honor, just regarding the time, the plaintiff did come to court and file his complaint timely. The issue with the tolling, I think, really only applies if the court doesn't reinstate the case. If the court does reinstate the case, then it's treated as if the case had been timely filed, and that argument becomes moot. Second, as to the claim itself and the defendant's ability to investigate it, these are claims related to MRI referrals by a doctor. I think in terms of this particular claim, the records are there. The supporting records from spine specialists who ordered the MRI said, here's what they're complaining of, here's what my exam shows, here's my recommendation. MRIs are maybe not unique, but they certainly lend themselves well to a record review by an IME doctor, the defendant's choice, to say, I see what the complaints were, I see what the exam elicited, and based on that, an MRI would or would not be indicated. So again, I think the prejudice for not reinstating the case would be greater on the plaintiff than on the defendant.
All right, the court has listened to the argument on the plaintiff's motion for reinstatement of this case. Plaintiff cites for its support MCR 2612C1F, and basically arguing under the court rule that allows for relief from entry of an order where there are reasons set forth justifying such relief. That particular court rule, as well as the typical reasoning under the rule, as well as how the state of Michigan Court of Appeals typically deals with these issues, applies on all fours where there is a diligent effort to set aside an order that may have been improvidently entered, where perhaps a party did not appear, and there was some showing of a basis as to why they did not appear. They did not get a timely notice. The problem is that there was some effort to try and get this set aside, but then those efforts have miserably failed, in that the motions have been untimely, and that is why we are a year or so out from when the motion, or when the case was first dismissed. There was a substantial delay in filing a motion in a case that involves, of course, the 1 year back rule, that involves a short tail on notices pursuant to Michigan no fault law. And then when the court set a hearing on it, there was yet again a missed hearing date. It almost begs the statement of comedy of errors. I don't know all of what went on here, but the prejudice that may result from the case remaining dismissed is about the same on both sides. But moreover, as it relates to the application of CR 2612, it presupposes simply a situation where there is an order that was entered and there was a reasonable response to the entry of that order in an effort to get it set aside. The response here has been delay after delay and missed court dates, and a failure to timely respond to or to timely take action to get the order of dismissal set aside. For that reason, I am going to deny the motion to reinstate the case. The matter will remain dismissed on the court's denial of said motion. So ordered at this time.
Thank you, Your Honor.
Thank you, Your Honor.
I think a good day. All right, do I have someone on American Express versus Childress? Anybody here on American Express versus Childress?
No, let me see if we No. They filed an answer and we said it today. They filed an answer. That's why you gave the schedule to set it happens today.
All right, this is case number 21172892. This is American Express National Bank versus Noel Childress. And the matter is set on for a status conference, a scheduling conference on today's date. Notice did go out to the respective parties in this matter. It appears that no one has appeared, although this matter is set on today at 10 o'clock a.m. It is now 10:59. Accordingly, the complaint in this matter will be dismissed. This is the
Oh, okay.
I think you already took a note on that.
Uh-huh.
Yes,
Yeah, they doing this.
they come back.
You want to send them this?
That's that.
That's for this file.
Yeah, that's.
Okay.
And, This is the back in front of that.
Keep signing this one again. This one, the other one.
What you say?
The sign up that again.
It's you.
Yes.
Wow, you're right.
You signed it. It's like-
Yeah, I'm signing it.
Oh, you signed it, okay. No, no, no. Nah.
Just 'cause you right there. Wow.
Okay.
Yeah, we do have to.
So this one. Oh, set it up, okay, all right.
All right, this is case number 21-160-888. This is Kara Carson versus Oliver Management LLC. Today's 8 times simple trial regarding this matter. Your appearance for Kara Carson or Ms. Carson, if you're present, say something at this time.
Yes, Your Honor, I'm here.
All right, and good morning to you, Ms. Carson. I believe the last time that we were here, you were dealing with preparations for a funeral or something. Is that correct, ma'am?
Yes, I was dealing with the death of my mom.
Yeah, yeah. I trust that you're doing better. Those things are incredibly difficult. Thank you for being here this morning, ma'am. All right, for Oliver Management, you may at this time.
Good morning, Your Honor. Attorney Jessica Warfield, P85391 on behalf of Oliver Management.
Good morning, Your Honor. Coleman Potts, P78607 on behalf of Oliver Management as well.
All right, thank you, Mr. Potts. Good morning to you as well, sir. All right, and I do see that that it looks like I see somebody under the name of Evelyn Oliver on the Zoom as well. Is that correct?
Yes, Evelyn Oliver is present, Your Honor.
All right, thank you, ma'am. Good morning to you as well. All right, I've got this set up for a trial on today's date, and I know that this case emerges as a result of a complaint that was filed in this matter alleging damages. Just one moment. Alleged damages arising from a rental relationship. I believe that relationship terminated some time ago. Is that correct, Ms. Carson?
You said what? You said when did I move?
I said that you did in fact move. That relationship has been over for some time now. Is that correct? Are you hearing me okay?
Yeah, yeah.
All right. So how long ago did you move from the property, if you will?
August of last year.
August of 2021. All right. Thank you, ma'am. All right. So I'm going to get started with taking proofs in this matter in just a moment. Anything preliminarily before the court proceeds in this matter, Madam Counsel?
Not at this time, Your Honor. I do just want to make a record only because I see online that it's still there, that the only defendants left in this matter is Oliver Management LLC, not the individuals, Elvin Oliver or Arnold Oliver.
All right. The only thing I'm seeing is, remind me, Madam Counsel, at one point, I do see that there was Aaron and Evelyn Oliver. I believe there was a motion or something that was filed and a decision was made on the motion. Is that correct?
That is correct, Your Honor.
All right. Did you submit an order out of?
The order was attached to the motion, Your Honor, I do believe, but we didn't get a signed order back. So it may have gotten lost in translation. I do know when we submitted the motion to the court, we did attach an order to that. A proposed order.
Take a look, because of course, if you file a motion and you have an order attached and you don't get it back, you're supposed to go searching out, making sure. That's a technical way of blaming the lawyer. So I'm looking through here to see.
Listen, all learning experiences. I just got licensed in November, so I'm taking all lessons.
All right. I thought I'd tip you off there. Let me just look through here and see if I could see it attached. And I specifically recall now that the court did grant the motion and that the Olivers were dismissed out of this matter for reasons under law. And I was looking to see, it would be typically what I would do is I would sign the order that's attached, and it's also my typical thing that if there's not one attached, I usually draw up an order in that regard. Just one moment. All right, so Madam Counsel, I don't see a written order. I know that the court issued that order, and as a cleanup matter, if you will resubmit your proposed order to the court as soon as possible, the court will sign off on the order as has been previously determined.
Absolutely, Your Honor. You will have it today.
All right, thank you, counsel. Mr. Potts, anything preliminarily, sir?
No, Your Honor. We'll waive opening in this matter.
All right.
Judge, can Mr. Potts restate his P number, please?
78607.
Thank you.
All right. Thank you, Mr. Potts. And I thought that all the court reporters in Wayne County knew his P number already.
He said it so fast, Judge.
I know. I'm picking with him, and he knows that I am.
Oh.
Okay. Ms. Carson?
Yes.
Ms. Carson? All right. Let me. I'm gonna give you an opportunity now, ma'am, to you have an opportunity to give what's called an opening statement. The other side has indicated that they are waiving such opening statement. Opening statement is just a brief summary of what you believe that your case is going to show. You want to give me a brief summary of what you think your case will show, ma'am?
What could you explain about what you mean? What it'll show?
Yeah. So you probably had a case, and I certainly don't like to relate it this way, but you probably had occasion to see on television people making an opening statement and some type of TV trial. This is like a summary of what you think the case is going to show. I believe that my case will show that this and this and this happened, and that as a result of that happening, that I'm entitled to a judgment in X amount. So if you want to give a summary, you can give a summary.
At this time, Your Honor, I got a lot going on. I didn't even have that prepared because I still got other stuff going on. So at this time, I really can't even think straight to even make one right now.
right, so I mean, explain that to me. Are you prepared to go forward with your case today or not? What's, talk to me.
Yeah, yes, I'm prepared to go forward with my case today. I'm like still in shock, Your Honor. So that's why I got a lot going on. Oh my God.
So, first of all, your device is, I'm having a hard time kind of hearing you, so I need you to stay close to your device, and let me try to understand what's going on. I know that recently, and those things are significant, I know that recently you lost your mom and you had to arrange for things. How long ago was the funeral?
It was 2 days after the court date.
So, and
it was
we
June.
Okay, yeah, June 16th. Okay.
Court date was June 16th. Her funeral was the 18th.
Okay. So, ma'am, is it your feeling or your thought that you need a little bit more time, or that you want to go forward today?
Yes, I still can go for today, Your Honor. Just was still in shock. That's it.
Yeah. Well, I don't suspect that. I think all of us who have lost our mama, I don't suspect that dealing with something like that is something that is easily navigated, because I think it's been about 7 years for my mom passed. So yeah, that's a heavy situation. We've tried to give some time so that you'd be able to then come back and go on, try to start going on with your business. And if you feel like you're ready to do that, then I'll go ahead and swear you in. You can start telling me what you believe this case is about. Is that what you want to do?
Yeah. Yes, Your Honor. Yes, Your Honor.
All right. Now, are you able to appear on the screen visually, or you
Yeah.
want to?
Yeah, I thought. 1 second. My phone is acting weird.
All right, ma'am.
I'm sorry, Your Honor.
All right,
My,
not a problem. All right,
I barely can hear. That's why I have my ear to the phone.
yeah, and that's a bit of. Can you hear me better now?
Yes, I can hear you. My screen is broke. I just put my ear to the phone so I can hear you clearly.
Okay, all right. I'm going to try to keep my voice up so that makes things a little bit simpler for you as well. What I need for you to do now is raise your right hand to be sworn, if you will. You do solemnly swear or affirm that the testimony that you're about to give is the truth, so help you God.
Yes, yes.
All right. And given that you informed me that you were not able to really formulate a summation, I'm going to move past the opening statement. The defendants have waived their opening statement as well, and so I'm going to allow you now to tell me what this case is about. I know that you at some point rented property from Oliver Management LLC. Is that correct, ma'am?
Yes.
All right. And how long ago did you first start renting property from Oliver Management? How long ago?
April the 6th, 2019, Your Honor.
All right. And at the time that you began renting in April of 2019, did you sign a document to start the relationship?
Like a lease?
Yes.
Yes, I did.
All right. And was that lease for 1 year or longer, or what was the nature of that lease?
It never was explained because it was like a weird whole situation because the lease didn't come to after,
Okay.
She didn't explain it. I'm gonna say that.
All right. So you didn't get the fully executed lease until sometime after you moved in, correct?
Oh, I got the lease the same day that we talked. I gave her the money and she gave me the key.
All right. So when you signed when you signed off on the lease, you got the keys. What was your understanding as to what the agreement was? Tell me what your understanding was, ma'am.
she just said, she never did say nothing. She just said sign a lease. She didn't ever say anything about how long the lease would be. She just said, do you want us to sign the lease, me, her, and her husband? And
All
she
right,
got,
I can hardly hear you now, so you need to be somewhere near your device.
it was me, her husband. They didn't ever explain that part. And I just signed the lease, me, her, and him, and they gave us the key. That's it. And I gave her the money.
All right, so when you signed the lease, you indicate that that was not explained to you. Did you draw any conclusions, or did you think that it was for a year or for 6 months? What did you think at that time?
I didn't know because I never got the explanation. So I didn't know. I thought that once you move in, you just had a lease till you move out, because she never said nothing. I don't know.
Okay, all right. So part of your agreement was to pay a certain amount of money per month. Is that correct, ma'am?
Yes,
And what was the agreement regarding how much you would pay per month?
$600. It was discounted rate. She was saying discounted rate because of something, and I'm like, huh? But it didn't matter. I was like, okay. I didn't know what she was trying to say. She said, she was just saying discounted rate for something because she could get more for the house, and I'm like, okay, what's that about? But after I moved in, I see what she's talking about because the house wasn't fixed. That's it.
All right, we'll get to that, ma'am. So your agreement was that you would pay 600, and there was some talk by Miss Oliver that 600 was a discounted rate, correct?
Yes.
All right. And was the rent due on the first of the month?
I think so.
Okay. And did you pay any security deposit or anything in order to move into the property?
Yes.
All right. How much did you put down to move in, ma'am?
I think it was 900 or 1,000. I can't remember because I didn't get a receipt. We just transferred over. She gave me the lease and the keys, and then it was that.
Okay. All right. And this property that you rented, was this a single family home or was this an apartment? What was it, ma'am?
Single.
All right. And how many bedrooms in this property?
It was like 3. Yep, one upstairs, downstairs. Well, upstairs that you make into a bedroom. I'm gonna say that.
All right. So okay, very well. And regarding any bathrooms, how many bathrooms were there?
It was basically I'm gonna say one because the one in the basement was, it's 2, but one in the basement was not together.
All right. So you were never able to make use of the basement bathroom, correct?
Never used of the basement, period.
Okay. All right. Okay, ma'am. So you moved in April of 2016, and when did you move out? I think you told me previously, but remind me again. You said you moved out sometime in 2021. Is that correct?
Yes. Yeah. August 2021.
August 2021. Okay. All right. Now you filed a lawsuit indicating in your lawsuit that there were problems on the premises, and as a result of those problems, you believe that you're entitled to damages. Is that correct, ma'am?
Yes.
And in fact, your complaint, you have alleged that you're entitled to damages of about $17,000. Is that correct?
Yes.
Okay. All right. So, tell me about your case then. Tell me what happened that caused you to believe that you're entitled to the $17,000, ma'am, or any amount. Talk to me.
Well, like I said, I moved there April 2019. So a couple of 2 months after it started flooding or whatever. I'm like, what is this about? So it kept flooding. I tell her, sometimes she'll be like, well, if I'm not moving fast enough, I don't know what to tell you and stuff like that. So I have other people. I started getting stuff fixed myself because I didn't have time for it. Like one time, half of the lights went off and it was freezing cold. And she didn't come out or whatever. So I'm like, oh my God. So I had to have other people starting to fix it. So after so long, started fixing, my money started getting low. So my mom kept telling me, this lady got to fix this house. This lady got to fix this house. She know it's like this or whatever. So I said, I did tell her. I told her. So after so long, I'm like, this is not fair to us. So the next year, I end up and I call in June, I called the inspectors or whatever. And when they came out, they inspected the house and failed it or whatever like that. So it's like been a living nightmare on Elm Street that I just can't believe that I had to live through it, constantly flooding in the basement, like majority of the time. Mold for days. Like when I leave out the house, I smell like mold. People don't even want me in their car. I've been sick. Me and my mom was sick from the mold. You tell her, it's like she act like it's, I don't know. Judge, I just know I end up and call the inspector. It took so long for her to do work. Like it was like a whole year and a half before she even finished the work. So at the end of the day, we had to go through the process. And then as we going through the process, I've been looking for a house to move, but it was so hard or whatever. So we didn't have no other choice but to stay there because I didn't want to be homeless. I didn't want to be out. I've been looking, trying to get help. I called some of everybody. So that's what sums it down to it. We ended up, what I was gonna say, we ended up having to leave, and the city came and got us out the house 3 days prior to when we're supposed to move out, and been helping and calling and trying to help get into a house or whatever like that. And like now my mom have passed, so it's like I'm just in the midst of, that's where I want to go now. So I don't know. That's all I can tell you right now, Your Honor.
All right. The attorneys are going to ask you some questions in just a moment. I want to just ask a couple of things here. You indicated that the city moved you out of the house at some point.
Yes, they came out to the house and they said we have to move you out of the house because you cannot stay here no more because of the situation. Code blue, something like that.
All right, gotcha. And you indicated that prior to that occasion, that you had called upon the city inspectors and they came to the home on at least one occasion, correct?
Yes, more than one occasion because he said he failed her twice. So.
Okay. And so they wrote some violations on the property, did they, the city?
Yes. Everything you can name almost. And I had got my own inspection report just to have my proof.
All right, and you've attached those items when you filed your complaint. You attached information regarding the inspections, is that correct?
Yes.
All right. You said the first 2 months that you were there that it wasn't until after the first 2 months that the flooding started, correct?
And then like it was like the roof was leaking in the living room. It looked after so long, the little the shingles on the house, it was like basically tacked on there. It just slid on down and then you could see the hole. So I don't know how long it was raining in there. I just know I just know I had to do something about it. That's it.
So so you had a problem. So let me ask you this. Is it in fact true that your major problem with the property? I know that you were saying there were several problems. I'll let you tell me about them, but you said your major problem was, number one problem was just continual flooding and leading to mold problems in the basement, correct?
Yes.
Okay. You said, go ahead, I'm listening.
Oh, and it's like when you turn on the heat, it make it even worse. And so we had tried to get heaters so that we try to keep down the smell much as possible. It wouldn't work. So it is what it is.
All right, and you said something about the winter time or something. You said it was cold in there.
Yeah, the furnace never.
The lights went out or something and it was cold. Tell me about that now.
Okay, she had to screw in fuse boxes or whatever. It was an older fuse box. It went out like 3 or 4 times in the winter. So I called her and she didn't come out. I went and woke one of my friends up and asked him, could he please come over to help because we in here, it's cold or whatever. It happened a couple of times or whatever. But with the fuse boxes, the only luckily thing was I knew where to go to get those type of screws, and it wasn't too far from the house. Other than that, did nobody sell them that I know of.
So
And
there
then-
come a time, oh, I'm sorry, go ahead, ma'am.
And then with the power being out, the furnace, it never worked or whatever. But you know, we had to abide with that. When it started working and it went off for the rest of the time. So I'm like, this is ridiculous. I didn't know what to do. It's just a lot to it. So thank you. That's all I have to say right now for that situation.
Okay, so in relationship to rent regarding this property, I know that you started out by giving a payment of $900,000 as security of first month. Did there come a time when you stopped paying rent, or did you continue to pay rent? What happened then? Okay, you're breaking up now. Hold on a second.
It was in July 2020.
Is when you stopped paying rent?
Yeah, and Sarah offered to pay, but she didn't have the right information or whatever. She didn't want any money.
All right. And did you receive a notice at that time?
I'm sorry, Judge. You said, was that July 2020? I was just trying to take notes.
It sounds like she said July 2020. Is
Okay,
when-
thank you.
When she stopped paying any further rent, and that the defendant did not want any further rent at that time. My question to you is that at that time, did you receive any notice of eviction or desire to remove you from the property at that time?
No, the city came out and she had to do some work and get that together, which she didn't get that together till the next year in May.
All right. And did you pay any other rent after that time?
No, I actually had to start fixing stuff in the house because she wasn't. Then we had to get hotel. It's just a lot. It was a constant everyday thing that we had to do something in the house. Once it rained, it's just weird. You had to mop up, clean up because there's stuff everywhere.
Okay. So after May of 2021 or during May of 2021, did things improve in May of 2021?
May of 2021, my mom had major surgery. So at that point, I was worried about my mom or whatever like that. And she was going downhill. So that's when I started getting nervous.
Okay.
I just try to do anything I can.
Absolutely. So what I needed to know, and I know how difficult that is, but what I needed to know is that was the house livable starting in May of 2021?
May of 2021, no, it was not livable. I mean, it was still in the same condition. It was still basically in the same condition. She was going like, it was basically oh no, May she ended up and had the inspection and the man came out, but it still was proper.
Okay.
And I have an inspection report on when after he came out to explain, because I explained to him in his face and Miss Evelyn's face. I pointed out every problem that was still there, and he just waved me off.
Okay. So to the best of your knowledge, what problems were yet going on in May of 2021?
Plumbing, electrical, still the mold, and still the same thing because she was doing plumbing and electrical all the way to the end.
All right. All right. So what caused you to move out of the property? How is it that you came to vacate the property in August of 2021? You told me that someone from the city you out 3 days before you were intending on moving. But go ahead and talk to me, ma'am.
Yes, July, I put in the paperwork for to put in the thing, and then they said you had 30 days to move or whatever. So I was moving. So particularly on this one day, the city just rolled up and was asking me questions and told me that they came to get us out of the situation, this, that, and the other, and that's how we end up in move. Other than that, we wouldn't have been there, but we still ain't, I'm still basically in a situation.
All right.
I got a house, so like I'm still in a situation.
All right, so what are you asking the court to do in light of the things that you have told me about? What do you want the court to do?
For right now, it's still like I should be compensated for a lot of stuff that was going on. And it's just a pain. It's just a lot of stuff that went on that it's unexplainable, Your Honor, because I went through so much, and I just want to. It's unfair for me and my mom to have to live like that, and she know it, and she knew what was going on. That's all.
All right, so how much are you asking the court for? How much money did you spend? Tell me about those kind of things, if you will.
Oh, I spent way over the amount that I even put down because my mom was putting money in different, different stuff. Because I put in, my stuff never even got out of storage from that. Like after I moved in, I started cleaning up the house or whatever, and then I said, well, I'll wait to get my stuff out of storage. I was bringing little stuff at a time, but after I bought it, it's like the house is messing my stuff up. And I didn't bring it all. Once I bought that little bit, I just had to throw it in the garbage, and then I just collected whatever I kept. But I kept my stuff in the storage. But it's just like I spent like on cleaning products. I had to buy cleaning stuff every day. I tried to get the mold out. I went to Home Depot. I went to everywhere to get the mold smell out. I was mopping the basement floor every other day. She had people to come do the work, and they left it a mess. And I end up having to clean it up or whatever. I sent pictures to the inspectors like this is like this. Her husband said he was supposed to clean it up, but he left and he said that he had to go to work. So I was like, I'll just clean it up myself. Then when I started to clean up, here he coming over, just going over it or whatever. You didn't even have to come.
All right, so
And it was like stuff going on 2-3 times a week with the house.
right.
Every time it rained, it flooded all the way to the top of the stairs.
And who else lived in the home with you, ma'am? You, your mother, who else lived in?
Me and my mom and my brother.
You got to hold your phone away. Let me stop you. You got to hold your phone away for a moment because I heard you and your mom, and then it also just started breaking up. You and your mom. Who else lived in the home?
My brother was over there from the get-go to help my mom while I worked to be in a house. But after once I called the city, Miss Evelyn was doing the most. So for my protection, I just wanted people to be over there with me so if anything happened, they can see exactly what was going on.
All right, ma'am. All right, thank you, ma'am. So do you have, did you keep any calculation as to exactly how much money you spent on cleaning products or having people to come out and make repairs or anything? Did you keep any calculations? I know you submitted a lot of stuff. Did you keep a calculation as to what you spent?
Yeah, I did, but it was way over. Like I said, it was way over the amount of that. When I went down to file, I just put $10,000 on there because I was by myself. If my mom wanted it, I was going on behalf of my mom or whatever. So by her not can't. She just had surgery. She couldn't even get up and leave. It was just a lot, Your Honor. So I went myself, and with some of it, I do have receipts. Some of it is storage. I had to touch my mom. Then.
I'm sorry, Your Honor. She's breaking up really bad.
You're breaking up. You're breaking up quite bad there, ma'am. And I think it's because I know that you hold the phone up close so that you can hear me. I'm trying to keep my voice up, but you do have to hold the phone away from you a bit when you're talking to me, because otherwise you start breaking up and we can't really understand what you're saying. Okay. I was asking you about what money you spend and whether you kept a tally on how much money you might have spent to correct things. And you were telling me something about your mom and whatever she wanted you to do and those kind of things. So go ahead and tell me what you wanted to do. Hold the phone away from you a bit. All right.
it was, I had, a living room set up, it was leaking other stuff. So, the room set, and I had clothes and.
No.
Yeah, my court reporter is having a hard time being able to hear because you're breaking up, getting a lot of static. So I need you, what I need you to do is when you're talking, I need you to make sure that that device that you're talking into is not shaking or moving or anything. You need to position yourself, start talking, and then just hold that still so that it doesn't sound like you're underwater, okay? So go ahead, let's try it now.
Yeah. Yes, I had storage fees, right behind the TV. A lot of stuff got messed up, and a lot of messed up from the smell of mold, like the wet, like I can leave out the house and come back, my stuff is wet up again. So it's a lot of stuff that I didn't even add in there that I was just frustrated about. Like, and then like with the toilet, I had a receipt for the toilet. With the others, like with the little thin people, I just thought people like, could you please do this for me? How much you charge and all like that. Some of them didn't even give me a receipt, just friends and stuff that I had come over. Like, please, could you get me out of this situation?
All right, ma'am. Just one moment, ma'am. All right, you may make your inquiry, counsel, one at a time, if you will. You may.
Thank you, Your Honor. Good
And just
morning.
Mr. Potts, I'm sorry, sir. Ms. Carson, you have way too much moving around going on. That's, and I know that you listen in to try to hear me on your device, but it's too much moving, and that moving is making your sound. It sounds like it's clear, and then it starts sounding like you're underwater. It starts sounding like a little. Okay, so you got to get stationary. You got to stop moving the device, and you got to maybe sit it still or something, because as long as you're moving that device around, it's going to always sound. It's going to always start distorting the sound. So I'm going to ask the attorneys to keep their voices up, and then I need you to just make sure that device is not moving around. Okay, Mr. Potts.
Can she mute herself, Judge?
No, I don't want to do that. That's
okay.
Now, thank you, Madam Reporter. But no, that would probably cause a few more problems. But we're going to try to keep it in sequence. Mr. Potts, you may, sir.
Thank you, Your Honor. Good morning, Ms. Carson. Again, my name is Attorney Coleman Potts, so one of the attorneys for the defendant in this matter. Do you recall the address for the subject property where you rented from Oliver Management?
Yes.
And what was that address?
14801 Quorum.
And I believe you testified already that you had a lease for this property, correct?
Yes, I had one lease, and it was a forged lease that she sent me.
When you say forged lease, what do you mean?
She sent me a lease with my name already signed on it and her name already signed on it. Where she got it from, I don't know.
I believe you testified just a few minutes ago that you signed the lease, correct?
It's two leases. The one I signed have three names. The one she sent me have two. Both of the leases are in with the evidence in the police.
So it's your testimony today that you did sign a lease, correct?
I signed a lease at the house, a lease, not two.
Okay, and that lease was with Oliver Management?
When I signed the lease, it was the husband and wife there. I didn't know about the management company till after I paid the rent.
Okay, but you did sign the lease in order to rent the property, correct?
Yes.
Okay, and you said, I believe you stated one of the terms of that lease was to pay rent in the amount of $600, correct?
Yes.
Okay. Now, did you read this lease before you signed it?
She didn't let me read it. She hid it behind her back, and then she said, just sign here or whatever. Then we went on from there. She knew what she was doing.
So it's your testimony today that you signed the lease, although you did not read it.
She didn't let me read it. Yeah, I didn't read the lease. I signed it. That's how she had things going. I don't know.
Could you have read the lease?
I couldn't read it unless I snatched it out of her hand.
Okay.
I didn't know she had it behind her back the whole time we was talking. When we got finished, she was like, okay, you could sign here, had her husband sign it, and then sign and got the money.
Okay. Did you ever get a copy of the lease?
I got the original lease handed over to me when I signed it with the 3 names on there. The one that she sent me is the 2 names.
Okay. So it's your testimony today that you signed the lease. When you signed the lease, was the lease in your possession?
I have the lease. I had the lease the whole time. She sent me another lease in February. She called me and said, Karen, can I tell you something? I'm just going to send you a lease and sent it.
Okay. I'm just trying to make sure everyone's on the same page about this. You testified that you signed the lease, correct?
I signed the lease with the 3 names. The 2 names, the one that she sent me with the April on it, that's the forged lease that she sent me.
Okay.
I signed the lease.
And when you signed the lease, you had the lease in your possession in order to sign it, correct?
She handed it, yeah.
Okay. But you testified that even though you had the lease in your possession, you didn't read it.
She gave me the lease after.
Okay. Did you understand by signing the lease, you'd be bound by the terms of the lease?
She knew what she was doing.
That wasn't my question. My question was, did you understand by signing the lease that you'd be bound by the terms of the lease?
I guess so. Yeah. I mean, I thought everything was legit. I don't know, this my
Okay. And one of the terms of the lease was that you pay rent in the amount of $600 a month, correct?
Yes.
Okay. I believe you also testified earlier that from the period of July 2020 to August 2021, you did not pay any rent at the subject property, correct?
No.
Okay. So it's your testimony that for over a year, you lived in this property owned by Oliver Management rent-free.
No, Sarah asked to pay. She didn't have her things together, so she denied it when she forged the lease.
Ma'am, the question I asked was a yes or no question. It's your testimony today that you lived in the subject property over a year rent-free.
Sarah offered to pay. She didn't have her things together, and they would have paid for it.
Ma'am, I'm asking a simple yes or no question. Did you pay any rent between July 20 and August 2021?
No.
Okay. Ma'am, have you ever been convicted of a crime of theft or dishonesty?
You say what? I couldn't hear you.
Have you ever been convicted of a crime of theft or dishonesty?
Unless you formulate, stop, ma'am. Unless you formulate that question, unless you formulate that question a little differently, counsel, I won't allow her to answer.
I'll withdraw the question, Your Honor.
You asked me that? Oh, never mind.
Excuse me, ma'am. Just wait on the next question.
Did you inspect the premises before moving in, Ms. Carson?
Did I inspect it? What you mean?
Did you look at the premises before you moved in, before you took possession of it?
I looked at the premises and she had it put together as if it was a house.
So your testimony today is that the premises was in good condition when you took possession?
No, it wasn't. I didn't notice that it was messed up until after you move in. You cannot notice until after you move in. You won't notice that it's a leak. You won't notice this until after you move in. If you walk through a lot of stuff, you're not going to see.
Okay. You would agree with me that one of the terms of this lease you signed dealt with the condition of the premises, correct?
The lease I signed had this little words. She had the words in the lease. That was the whole point of her not wanting me to read it. And it say tenant willingly got this price. You just made the lease up. You could have printed that in the lease instead of writing it.
You would agree with me that the lease contains a provision that states that the property is in good condition.
The lease didn't state that. She wrote it in.
Okay.
But on the list she probably gave you, she took it out.
Never did this via Zoom before, but I'd like to turn the court's attention to the defendant's proposed Exhibit 1. That will be the rental agreement. Oh, I gotta turn my blur off.
Let me ask you about that document. On the third page, is that a 3-page document, counsel?
On the third, yeah.
Yes, Your Honor.
And it has, on that third page, it has 3 signatures and dated April the 6th of 2019.
Yes, Your Honor.
All right. I will allow you to offer that document as the rental agreement of the parties. And you may offer that as defendant's number 1, and I'll receive that document. I think that's a crucial part of this case. All right, and I do have a copy of it, counsel. You may proceed at this time.
Okay. I believe Ms. Carson, you already testified that you don't recall the terms of the lease. But you would agree with me, if you were to see a copy of the lease, would it refresh your recollection?
I got a copy in front of me.
Okay. Do you see a vermin? Do you see paragraph 14, condition of premises?
Hold on, let me turn to it. Paragraph 14. Oh yeah, and do you see on the side what she written into it?
I'm just referring to the type part. You would agree with me that states the tenant hereby acknowledges that said property is in good condition.
Oh, it's something written into it. She must have erased it. It say something she written into it, tenantly, willingly. It's on there. I have both leases at the court.
All right, let me ask you this, ma'am. Let me stop you for a moment. You're looking at paragraph 14 in this document, and I need you to answer the question that is asked of you, and that is whether or not in that paragraph it says that the premises are in good condition.
Oh, I got 2 different leases. I got the original one and the what's now. On the original one, it doesn't. It got something written. I wish I could show you. Like it's something written, and on the one she sent me, it doesn't have the written in thing on it.
So what you're saying is that you have a document where paragraph 14 does not have any typewritten language, right?
It have like a handwritten thing. It have it in there, but it have something where it say in good condition. It have a little hyphen in there, and it say tenant willingly property is in good condition.
All right. Thank you, ma'am. Counsel, go ahead.
And you already testified that you signed this lease, correct?
Yes.
Okay. And this was April 6, 2019 that you took possession of this property?
Yes.
Okay. When did you first notify your landlord that there was an issue with this property?
Like 2 months after.
So when would that have been?
2 months after.
I mean, you're testifying, ma'am, but is that May? Is that June?
For purposes of this record, 2 months after that time would have been sometime in June of 2019, correct, ma'am?
Yes.
All right, go ahead, counsel.
And when you notified her, you notified her in writing?
No, a call. A call. I have her phone number. I had my mom to do some of the calling because of Mrs. Evelyn's demeanor. I had my mom in the car.
Okay.
For the first start for some of it. And then I said, this not gonna work. I'm gonna have to call.
So in June 2019, what was the issue you notified the landlord about?
Flooding, mold. And there was a pipe in the basement that was making it flood in the inside. So it kept messing up, and a little while down the line, we called her again about that.
Okay. Do you have any pictures of this flooding or molding?
And electric problems, like it's this the main PV thing, it wasn't right, so it was blowing electric appliances, and I'm telling her that.
Ma'am, did you have any pictures of this? Do you have any pictures of this flooding or molding?
Yes, the court has it.
Okay. Did you present any of those pictures today?
What you mean present? The judge, I put it in when the case first started, I put all the evidence in.
Okay, when you were presenting your case on direct testimony, did you present any pictures of any flooding or molding?
Yes.
I believe that, for the record, counsel, I believe that defendant that plaintiff made reference to documents that she had submitted to the court. And the court does have a complete plethora of documents from an agency called After Hours Residential Building Inspection Report from September, looks like September 3rd, looked like something from May of 2021. There are a number of documents together with photographs. She also submitted to the court a property maintenance inspection report from the city of Detroit, together with a number of notifications that relate to violations. And then the other part of this is a number of photographs that she has submitted to the court of the basement, of various plumbing conditions, of various conditions that she alleged regarding electrical. So there are photographs that seem to be what she intends to offer that are throughout the house, and she's offered them to the court. I did not ask her about marking them because they are so numerous, and I thought that on cross-examination, perhaps that the parties would be able to come to some reasonable way of actually having these voluminous items admitted into the court's record. So that's kind of where the case is, and the court tried to guide some of the presentation of the plaintiff's case so that we would not go on and on and on and on about things that are repetitive in nature and so on and so forth. Yeah, I understand that sometimes some of that may be necessary, but I try to stem tie that a little bit. It seems to me that the probability is that at least some of the inspection type reports, some of the photographs that are showing various conditions throughout the premises would be relevant and admissible in this case. And I think that that's kind of the bandwidth of what goes on here. Let me go off the record for a moment, Madam Reporter.